it seems as if we can't hear each other, but you guys can all hear us, but each of us. So today we're looking at NEC case law. So just a quick introduction. NEC, to those oldies in the room, and I include myself, is now 27 years old. So some of you might not even be as old as the NEC form of contract, which is a bit depressing for the rest of us. There still isn't a huge amount of case law. Probably for the first 10 years, NEC was hardly ever used. In the last 17 or so, it's been extensively used. But of course, as we'll see, adjudication is mandated as the first port of call in disputes rather than court proceedings. So possibly because of that, we've not seen the level of case law that you might otherwise have. It's still a bit of a funny mix insofar as there's a lot from Scotland and Northern Ireland, not so much from our courts here. So the Scottish and Northern Ireland cases are persuasive rather than binding on us. And that there's one in particular, Northern Ireland case, which we'll come to, where I'm not sure whether our courts will follow it, but you know, that's excitement to come. So today we're looking at 14 cases. I would say there's no 100% guarantees, but these are pretty much the 14 key NEC cases. So if they're not here, the chances are there is no case law on a particular issue, and you've just got to revert to the guidance notes and general contract principles to interpret it. The oldest is from 2010, which highlights my point that, you know, the case law is, you know, it is all relatively recent, whole range of topics, some of greater importance than others. My view is with these cases is that they're pretty much they pretty much go where I would have expected them to. I suspect, though, construction professionals, so possibly you guys, might disagree on that. So the first case is on our most important clause, clause 10.1, mutual trust and cooperation. Now, I kind of say that in that it is the most important clause. It's the first clause in the contract. It's the whole ethos of the NEC form of contract. But does it really have much impact? I think that there's this case and there's another one where we touch on mutual trust and cooperation. This is the only case that really supports use of the clause. So I would still say that, you know, bringing a claim wholly on the basis of mutual trust and cooperation is not going to be the best strategy in the world. You need really to have other clauses to rely upon, and unless there are some real extenuating circumstances. So in this case, it doesn't really matter which contract it was because all the NEC contracts have this clause, and it's the final bullet point that is the key point, and that it's basically that mutual trust and cooperation at the moment, the highest it goes is that, you know, you mustn't mislead the other party. You mustn't, you know, represent that, you know, there is a positive or negative obligation one way or the other in a misleading way. So it's not going to be extensively used. Having said that, I mean, this case is 2017, and I must say, for a couple of years afterwards, I was using it in several instances where we felt that the party that I was representing had been misled in one way or another. So it's things like, you know, these, you know, it does happen, you know, representations that you don't need to bother about your 8 weeks or 6 weeks or 7 weeks or whatever it is in your contract to notify CEs. Sometimes the paying party, so the client or the contractor and a subcontractor, will say that in correspondence. My view is, don't rely on that, still get your notifications in, but if you have, this is probably the case that we'd be relying on to say, well, actually you can't now backtrack on that. The mutual trust and cooperation clicks in at that point. This was a case, from recollection, it was about timescales, and the claim was that one of the parties had represented that certain timescales weren't applicable, and the other party had relied upon it. So again, things like that, particularly where there's been reliance, just be careful. So be careful on two scenarios. Be careful about making those representations if you're that party, because you might then find that you've bound yourself when you didn't mean to via this mutual trust and cooperation. And equally, if a situation is arising where you've relied upon something that the other party has said which is incorrect, you'll be able to rely on this provision. I think that just deals with the case. So I'm just going to skip over that because we've spent a little bit of time on it. So the next case is a procurement case. So this is Henry Brothers and the Department of Education for Northern Ireland. So it's a Northern Ireland case. Bear that in mind. It's persuasive, not binding on our courts. I think this would be followed in our courts. It's probably more relevant to how you price and how you cost NEC rather than anything else. And it's also, I think, interesting in that I think it shows that, as at 2008, authorities still hadn't really got to grips with how NEC was costed and priced, because I think this is what this shows. So it's all about public procurement. Henry Brothers had tendered for this, £500,000 school modernisation programme. Because it's schools, obviously it's on the EU procurement rules. And it was all under an NEC 3 standard form contract, so the engineering and construction contract. Henry Brothers didn't win the tender, they weren't appointed, and obviously, they were slightly disappointed, as you would be if you'd lost the opportunity for £500,000 worth of £500 million worth of work. That's probably why I'm not a millionaire yet. Still don't know my numbers. What happened was, as often happens, Henry Brothers wanted to challenge the process and whether the whole thing had been marked and assessed properly in accordance with the rules. And the basis of the tenders had all been that it had to meet the MEET criteria, so the most economically advantageous tender. Now, when Henry Brothers looked into this, what they discovered was that the whole of this MEET criteria, so we're talking about the money, we're talking about what's going to be paid, the authority, the Department for Education, had assessed it using only the fee percentage in the NEC form of contract. And Henry Brothers said that doesn't meet the MEET criteria. It doesn't mean that because they've picked the lowest fee percentage, that is necessarily going to be the most economically advantageous tender. And the Department for Education said, well, yes, of course it does, because that's the only real variable, because the rest of the contract is all based on actual cost, defined cost, etc. And of course, everybody's actual cost is the same, isn't it? And of course, Henry Brothers said, absolutely not. One contractor's defined cost, actual cost, will be completely different to another. So the fee percentage is only one relatively small part of working out what the work's going to cost, and therefore the most economically advantageous tender. And the court agreed. The court said that is absolutely right. This is about not only the fee percentage, but the other rates that are going to be charged, or the actual cost as it should be in reality for NEC. So be aware of that, contractors and subcontractors, particularly contractors, because I have won effectively procurement challenges based on this case, where we have looked at the way that the tender has been put out and said, well, actually, the pricing mechanism that is being judged here doesn't necessarily reflect the most economic method of doing it, not just on those facts, but on a wide range of matters. So that's quite a handy case on procurement generally, but as I say, I think it's useful in terms of acknowledging the pricing mechanism within NEC. Next case on payment provisions. This is SGL Carbon Fibres and RBG. So this is SGL is the employer, the client here, and it was work to SGL's new factory, NEC 3, option C, so the kind of pain gain profit sharing mechanism. So as we know, under NEC you have an assessment date. Usually under NEC it does tend to be monthly, although of course it could be milestones under the Housing Grants Act. Under this particular contract, it was pretty standard. Project manager was required to make a monthly assessment of the money due to the contractor. Now, that mechanism wasn't followed from the start. So this is an interesting case from our perspective, where neither party have followed the NEC form of contract. Now, be very, very careful here. It's not where one party hasn't followed it. It's where both parties haven't followed it. So just be careful about that. What the parties did instead was the quantity surveyors for each party got together every month and basically thrashed out and agreed a figure. So actually quite a nice, civilised, sensible way of doing things. And payments were made on that basis. So, all very friendly and happy. Until, of course, we get to the end of the project, where the employer suddenly realises they've paid more than they wanted to, and wants to claim some money back on the basis of an overpayment. So what they do is they argue, well, we've not followed the mechanism, so we just wipe that all out. Nothing's been done properly, so we just get our money back, and then it's for the contractor to go through and prove every single application that they made and what they're entitled to. So as we can see here, Scottish case, so authoritative but not absolutely binding on our courts. What the court said was that the onus was on the party seeking to prove its case. So in this case, it was SGL who had to prove its case. The court wasn't going to backtrack and basically trash everything that the quantity surveyors have done through the project. That it was the other way around. The employer had to start from basics and say, right, application 1, quantity surveyors agreed that this was the appropriate figure. That's not right for these reasons, and prove the claim on that basis. So that's quite an interesting case, particularly in circumstances where contractor or subcontractor has been paid and then one party seeks to claw it back. Okay, so this is the most recent case. It's a 2020 case. It's a Scottish case, so same old. And you might recognise from the fact that Dragadas are involved, it's an offshore case. So in some ways probably not massively relevant to us, but the principles are very relevant. So this was an NEC3 option B, subcontract. Dragados were the contractor, subcontractor was Van Oord, and the subcontractor work included, part of its work included this soft dredging work. Now, unknown to Van Oord, this is the fourth bullet point down, Savio is Van Oord, Dragados had given this soft dredging work to two other subcontractors as well. So it was basically covering all bases here. So later on in Van Oord's contract scope, Dragados omitted the soft dredging work from Van Oord's subcontract because obviously it didn't want all three subcontractors to do the same work and have to pay them for it all. So it's omitted the work. Van Oord understandably weren't too chuffed, particularly because it was, the work was carried out by the subcontractors. It wasn't that it just wasn't done at all. So they started court proceedings to make a claim to say that this omission was illegal. It's effectively a breach of the subcontract. Now, the issue around this was that effectively the way the contract mechanism worked in calculating the emission cost meant that Van Oord were going to be substantially worse off. Now, the court didn't deal with that point. It said that that needed to be dealt with later. So we may or may not see that coming through the court possibly next year. It may get settled, obviously, so we may never hear about it. But the issue that was raised was, as a point of principle, was the omission of the work from Van Oord's contract allowed, or was it a breach of contract? Now, omissions, are a CE, a compensation event under the NEC, but there are a couple of points here. First of all, which was a real problem for Dragados, there was an amended clause 14.3 in the NEC. So it's not in the standard NEC. But what the provision provided was effectively that Dragados could omit works from Van Oord's contract and give that work to a third party. So far so good. This is looking really good for Dragados. But they could only do that where the main contract project manager issued an instruction to Dragados to this effect. So it's effectively where Dragados have received an instruction from the project manager, from the client's project manager, omitting the work to give it to another party, and Dragados are passing it on to Van Oord. Now, that hadn't happened here. Very different situation. Dragados had just simply given the work to a variety of different subcontractors. So the court kicked that out and said, no, that scenario doesn't apply here. In addition to that, it also worked against Dragados because the court would look at that clause and say, well, Dragados, you have made certain provisions to omit works and give them to a third party. So in circumstances where you omit works and give them to a third party, but that clause 14.3 doesn't apply, then you're sort of on your first step towards a breach because you have made provision, specific provision in certain circumstances, just not these circumstances that exist. So that was the first thing that went against Dragados, the fact that they had made provision to pass work to a third party, but it didn't apply here. The second point that went against them was a general provision that we come across in all construction contracts where sometimes, unfortunately for you guys, once you sign a construction contract, the principle is that you have got to do all that work. You can't just walk off site if, it starts becoming uneconomic for you. It's very, very difficult to walk away. The principle is you've got to finish your works. The upside to that, so that's the obligation, but the benefit to you is that the principle is that you must be allowed to finish your works. Now, so generally, the general case law is that if client wants to omit works because it doesn't want to do those works anymore, then that's fine as an omission. But because of this obligation and obligation on both parties, that you can't allow client developer to omit works and give them to somebody, another party, particularly if it's to another party to reduce costs because they're cheaper, for example. So on those two bases, the court said it is a breach of contract what Dragados did. So that's why it's presumably going on to court, unless they have settled it, to determine how the financial aspect of that will proceed. And that actually will be quite interesting because it will be a case based on a CE for breach of contract by Dragados. So maybe it's not exciting for you, but for the lawyers, I think it's quite exciting in our world. Next one on compensation events. So this is ICI and Meritrill. So this is a case from 2018, but the dispute actually arose in 2017. Now, it's similar to the case that we looked at 2 cases ago, where the parties sort of did something slightly different to what the contract mechanism allows, in that in this case there were interim assessments were being made between and agreed between the parties. So again, slightly different to the mechanism, where the mechanism is that contractor submits an interim payment application, PM assesses it, and it's very much the PM assesses it and that's what's paid. In this instance, it was slightly different because they were talking it through. So again, a very civilized way of doing it. They were coming to an agreement on what the interim payment should be. And exactly the same thing happened. ICI got to the end of the project and thought, oh, we've paid more than we wanted to here. We want to claw some money back. And again, thought, well, what's the easiest way to do it? The easiest way is to say PM and contractor haven't followed the correct mechanism. They're not supposed to agree these interim payment applications. It's supposed to be an assessment by the PM. So if we just wipe all that out, it's then up to the contractor to prove its claim. And the court again said, no, we're not happy with that. Similarly to above, you can revisit it, no problem with that. But you as employer, as client, you've got the burden of proof. You've got to show why you should be entitled to money back. So, again, that's helpful where, again, it's helpful where both parties have moved away from the contract. It's not going to be helpful where one party's moved away but the other one hasn't. Again, another one on calculating compensation events. I think this is probably your most important NEC case. It's a Northern Ireland case, so persuasive, not binding. Northern Ireland Housing Exec v Healthy Buildings, not Buildings, as the typo says there. So what happened here? So this is all about how you're going to quantify a CE. And it's the issue that we have where you quantify your CE via a quote, and your quote predominantly is a forecast of your cost based upon the schedule of cost components or shorter schedule of cost components plus your fee. So you're predominantly, not all of your costs, but most of it is going to be a forecast. And the idea is you provide that forecast, project manager reviews it, agrees it, and then that forecast is set in stone. You've agreed what it's going to cost, and that's what you paid. And it also means that contractor, subcontractor, and a subcontract can include an element of risk, and if that risk doesn't manifest itself, contractor still gets that agreed price. If it does manifest itself and the costs go way over, well, that's the contractor's risk. And it's the kind of downside of NEC. And hopefully through the contract there are swings and roundabouts, so that some CEs come under the quote, some will be over, but the contractor ends up not doing too well or too badly. As we see in practice, in my experience, it's very, very, very rare to get that scenario. The usual scenario is contractor puts in a quote, it's not accepted, an assessment is made by the PM, which is imposed upon the contractor, so there's no agreement there. So everything's stacked up there to allow one of the parties to adjudicate at the end, because those quotes haven't been agreed. And this case is about that kind of scenario. So what we had here was 2 professional services contracts under NEC 3 in Northern Ireland. And in January 2013, the employer instructed a change, but as it says here, in breach of the professional services contract, and it would be the same under the engineering and construction contract. The employer didn't notify, so didn't issue that notice that it was a CE, a compensation event, and also in breach, didn't instruct or ask the consultant to submit a quotation. So eventually the consultant notifies the compensation event to the employer. In the meantime, the consultants actually completed the work, and at that point, the employer requests a quotation, which is a bit odd, because my understanding, and I don't think the dictionary definition doesn't quite support this, but I always understand a quote to be a fixed price. So that's a bit odd when they've done the work, but anyway, it's requested. So the consultant provided the quotes on the basis of what the NEC set up, of the way the NEC says that you provide a quote. So it's based on your forecast cost. So it was sort of a bit of a false quote, because it was, the consultant was going back in time and forecasting the cost, when actually it knew what the cost was by then. But you can see why it would do that, because NEC is very prescriptive that is what you've got to do. It's got to be a forecast at that time. So it was submitted. The employer, having requested the quote, then rejects it and assesses it at 0. So obviously, consultant wasn't very happy. Went to adjudication, as you're required to do. And neither party were happy, so it then goes to court. And the issue was that was dealt with in court was, how at this stage do you assess the cost? Do you do it on the basis the consultant did it, so in the strict requirements of the contract? You go back in time, you do your forecast, you put in a risk assess, an element for risk, etc. Or as the housing executive said, do you look at what it's actually cost you and base your claim, or calculate the CE on that basis? And the court said you do the latter. So very much like what you would do with JCT, you're looking at what it actually costs you, so you can forget about anything for risk, because all risks have manifested themselves and you're just costing, what it has cost you plus your fee percentage. So in some ways, a bit of an odd case for several reasons. I mean, first of all, it's odd in that it completely ignores the very prescriptive requirements of NEC, which is interesting. A lot of people here think the courts wouldn't follow that. So I'm not so sure. The reason that the courts went for the sort of what I call the JCT option of looking at the actual cost, I think is twofold. A, it brings some certainty because a contractor can prove what, or should be able to prove what the workers cost them. So actually that is fair to all parties. And also B, it's really going to be quite difficult for the courts to assess a quote when it is prepared, on a future, on a we don't know what's happening in the future basis. I mean, obviously, in this case, it was falsely prepared. But if it was a genuine quote prepared at the time before the work had been done, even then, it's quite difficult for the court to look at it, even with the benefit of experts, and come to any real decision as to what a fair amount would be. So, for example, that the amount factored in for risk, that would be quite difficult. They'd have to kind of assess, all the risks that could have manifested themselves, even if they didn't, and quantify them. Now, I appreciate you're probably all saying, well, we've got, this is the life we lead. We're doing this every day. But, it's not what the court is familiar with. They like to see invoices and what things actually cost and timesheets for people. So, who knows? The other point about this is that, it was all done back to front, of course. So, that would have been, quite a good reason, although it's not what the court said. But if the court in this case had said, look, this was all done back to front, they did the work and then produced the quotes. So actually, in that situation, we are going to look at actual cost. It might be different if they'd produced the quote at the correct time. I could sort of understand that, but the court didn't say that. They didn't draw a distinction between the fact that this was done back to front and a situation where it was all done properly. So, I don't know whether that would change the situation. So, it's a bit of a, this is where we are with the case law. It's not great for you, for contractors and subcontractors. But what I would say is, and I think it is a real pain, but you need to prepare your quotes, but you also need to keep records of your actual cost. So timesheets for people who are carrying out the CE work, what they're doing, how long it takes them, how it relates to the CE. You need all those timesheets so that you can quantify the claim. If it does go to adjudication, you need all your subcontractor costs. You need them to do the same thing. You need your plant, your materials. So you need to keep actual costs and be able to identify them as relating to that CE. You can't just say, well, I've got a timesheet here. We had 10 people on site that day, and it doesn't say who was working on the CE, so this is just guesswork. You need to kind of keep tabs on people and, how many hours a day individuals are working on, CE1, ditto for CE2, ditto for CE3, etc. So that you can quantify it if you need it. Now, what you might say is, oh, well, we're never going to go to adjudication. But what I would say is still get that documentation, because without it, you might find that negotiation's really difficult. With it, you can give all that paperwork to the client, you can show them you've got it, and that gives you some real leverage to say, I've got a strong case to go to adjudication here, the paperwork's in apple pie order, and hopefully that will persuade them to settle, even if you're thinking, well, it's really unlikely that I'll be adjudicating this. Mears v Shoreline, I'm going to kind of move on. This is really similar to previous cases where we have a claim right at the end of the project by the client that they've overpaid and they're clawing money back. In this case, it's a slightly odd case, this. I'm just going to cover it quickly. They had contract rates. the contract rates, and I think this is, yeah, it's term service. It's, if you do a lot of framework contracts, maintenance contracts, you'll possibly recognise this issue. They had contract rates over a period of time. As soon as they started work, they realised these contract rates didn't really work for the actual work that was being carried out, and this is quite common on framework and these term service contracts. And again, quite sensibly, they got together and agreed what they called composite rates, which was just a way of pricing the work, and that's what they used throughout. Now, at this point, they hadn't actually signed the contract, although they were pretty much operating under it, but they later signed it. So we've got a strange chronology here. We've got a contract not signed but probably being operated. The lawyers, could have a great time debating all of that. Then, we have a composite rates agreed and operated and used as opposed to the contract rates. Then we have a contract signed which has the original rates in. Now, what I would say here, guys, is, if this is your scenario, at this point, you need to be changing the contract. It's not appropriate to sign it and get your composite rates in rather than the original rates. That would have been the perfect thing to do, but we're not in a perfect world, as we all know. And the employer at the end of the project thought, we thought we were going to save money here, or we spent more, so they tried to claw money back. And again, the court basically said, they couldn't do that. Now, on this case, it was permanent and it was based on an estoppel argument. The others weren't. It was just talking about who needed to prove the claim to either claw the money back or retain the money. So this is kind of fairly unique, which is why I don't want to talk about it too much. And I suspect the courts wouldn't necessarily 100% follow this in the future. Interpreting the contract, I just want to talk about this very, very quickly, because this is more general legal principle than NEC, because what it concerned, so it's bullet 3, and you can see how this could so easily happen in NEC. So we had what were thought to be conflicting provisions with regard to completion date between the contract data part 1, so the bit that the employer fills in, and the works information. So these are both documents that are prepared by the employer or the employer's team. They were slightly different as regards to the completion date. The argument arose, is this a discrepancy in the contract? In which case we deal with it as a discrepancy, and it's a compensation event, or is it not a discrepancy? Now, basically what the court said was it wasn't a discrepancy, and why I wanted to refer to this is that, like everything in life, these things go in trends or in fashions, and at the moment courts are very, very reluctant to say there are discrepancies in contracts. What they prefer to do is to look at the two provisions and say, right, parties have signed this contract, so they intended both provisions to be in there. So we as a court have got to assume that they're not, that they aren't discrepant, that they're not discrepancies, that both clauses are intended to work logically with each other. And the courts will try to find a way around, a logical way of interpreting each clause, rather than find that they're a discrepancy. And that's exactly what the court did here. The court said, actually, we don't think there are discrepancies with these clauses. We can interpret them as, working together. So just be careful with that, because I do get lots of people ringing me and saying, oh, well, this is a discrepancy. And actually, sometimes it not being a discrepancy is more helpful to the claiming party. It's sometimes easier to argue it's a CE without it being a discrepancy in the contract. Atkins and the Secretary of State for Transport 2013 case. So this is sort of a beware to you all case. Again, this was a sort of, it was a management contract, so it was over a period of time. And again, it's sort of about this issue of rates that we've seen already. So it was a lump sum contract, but it was basically for Atkins to maintain, to carry out various specified works, 2 trunk roads in East Anglia. And what the claim was that Atkins said they found far more potholes than they'd budgeted for in their fixed price, and than could have reasonably been foreseen, and therefore they wanted extra money. So they claimed it as a compensation event. And at first you can kind of see the attractiveness of that. But what the court looked at was, firstly, that it was a lump sum, and the lump sum was, for the maintenance, which included repairing potholes. Secondly, the fact that there was no cap on the number or the type of potholes. It was just, repairing potholes. And thirdly, and this is where I think it's always helpful, you can look at these things, on an academic level, but, when you get down to it, how are you going to quantify this claim? And that was one of the areas where, this claim really failed at court, because the court said, this just cannot be quantified. It's a lump sum for maintaining the roads, including potholes. So how are we ever going to say, these potholes were part of the lump sum, but these weren't? How are you going to work that out? And it comes back to the fact, the reality is, well, actually, it's not a compensation event. It's a lump sum contract to fill in all the potholes. Now, this was unfortunate, and it shows how you can sign up to a long-term contract, and then the situation changes from what you possibly expected, because by the time it gets to court, it's substantially later, but the contract had been entered into, I think, just before the global recession in 2008, 2009. And of course, what did we see after that with highways authorities? Well, they were all trying to save money. So, rather than doing major works on roads, they were filling in potholes and, keeping them maintained at cheaper possible cost. So, I think there was a feeling that the contractor here, had suffered because of that. But of course, this is the point of lump sum contract. And it's the point that you sign it, and the situation might change, as it did here. Okay, so Anglian Water and Laing O'Rourke. So this is about dispute resolution. So this is the NEC 2 contract. I don't think the principle has changed at all. It's a fairly, I think, simple principle, and it is basically as to the dispute resolution methods in the NEC form of contract, and which you've got to go ahead with, and which you don't. And basically, the situation is that if you have a dispute under NEC, typically for us, we'd be under option W2, which is where the Housing Grants Act and adjudication applies. And in that scenario, you absolutely must adjudicate before you can go to what NEC calls the tribunal. And the tribunal is either court proceedings or arbitration, whichever has been picked in the contract. So in this case, it was arbitration. I think. Yes, it was. Actually, sorry, yes, yeah, it was arbitration. So for an NEC dispute, you cannot go straight to court or arbitration. You've got to adjudicate first, unless your contract has been amended. Now, you've got to be careful there, because of course you can't exclude the right to adjudicate. So, you know, if it has been deleted and you want to adjudicate, you probably still do have the right to adjudicate. But there may be certain disputes that when they arise, you don't want to go to adjudication, and both parties might agree that. So if both parties agree, then you can go straight to court or arbitration. But, you know, otherwise you've got to adjudicate first. Another dispute resolution, quick ones. This is Murphy and Maher. Now, this I think is pretty good news for contractors and subcontractors. We've always had, or kind of at the start when adjudication was first introduced, we had an issue where, you know, as often happens, you come to some kind of settlement agreement with regard to a construction dispute, and one or other of the parties doesn't implement it properly, so is in breach of it. And the issue would then be, could you adjudicate that dispute? Because was that dispute, did it come within the Housing Grants Act? Because to be able to adjudicate under the Housing Grants Act, it's got to be a construction dispute. Well, if it's a settlement agreement, you know, developer pays contractor X pounds, arguably that's not a construction dispute. It's a settlement agreement. It's a dispute about payment. And what this case said, and this is purely on NEC, was that the contract was wide enough to mean that a settlement agreement could be adjudicated upon if one party wanted to pursue the other party because they were in breach of that settlement agreement. And the relevant wording in NEC is that it says any dispute arising under or in connection with this subcontract. So your settlement agreement arises in connection with the subcontract, so you can adjudicate any breach of it. We've got a problem with our eyes today, haven't we? So this is time limits for option W1. So this is dispute resolution. We're not really concerned with option W1 because that's all about contracts abroad where they don't have the Housing Grants Act and the ability to adjudicate, or oil and gas disputes here potentially. But generally your work, civil engineering in this country, is, you know, you are going to be entitled to adjudicate a dispute, and possibly with some exceptions about the type of project you're working under. But you know, that's pretty rare. Why I refer to this is not particularly because it's about option W1, but it's about timescales. So I'm not particularly concerned about these W1 timescales for you guys. But what I am concerned about is it being analogous to other timescales in the contract. So, for example, you know, that really important one where you've got to notify your compensation events within 8 weeks under your main contract. And is it 6? I can never remember. It's either 6 or 7 weeks in a subcontract. I can never remember that date. Always have to check it. And how the option W1 works is in a similar way. It basically says there is a time limit to adjudicate under the contract. So this isn't a Housing Grants Act adjudication, it's a contract adjudication for those foreign, for the contracts abroad, or for oil and gas or whatever. So it says in the contract you can adjudicate a dispute. But what it says is that you've got to adjudicate it within, and usually it's about 4 weeks of becoming aware of the dispute. So it's a horrendous clause. because if you think about it, as soon as your CE has been rejected as a CE, you've got a dispute, so you've got 4 weeks to adjudicate it. Now that could be, your CE might be rejected, week 3 of your project. Your 4 weeks means that by week 7 you should be adjudicating. So you could have, numerous adjudications on at any one point. So pretty horrendous. So, be grateful for the Housing Grants Act, I guess, from that perspective. But what happened here was, and I think it was a contract, it's a professional services contract. So in this case, the adjudications weren't brought within that strict time limit. So they went to court to see if the court would relax it and let the dispute proceed. And the court said, no, these are strict time limits. We interpret the time limits strictly. So you can't adjudicate this dispute. You've missed your time, you've missed your chance. So it's really onerous, because it meant basically they couldn't pursue the dispute. So that's horrible for that. So if you are ever operating under W1, as a contractor, subcontractor, what I would say is absolutely get those timescales changed to, something like you've got to bring the adjudication before the end of the defects period, not these silly time limits. But aside from that, that's unlikely. If I was acting for a party who wanted to rely on time limits in the contract, I'd be relying on this case and saying, this case says time limits are to be, you can rely on them. They might have onerous consequences, but the courts, like these clauses and will uphold them. So just be really careful with your 8 weeks notifying compensation events. Ditto, if you're the client or the contractor, and we've got the CE provision where if the party the party being paid, so the subcontractor and a subcontractor or the contractor, notifies and gives a 2-week reminder, and within those 2 weeks PM or contractor doesn't come back, then there's a default mechanism. All parties need to be careful about this. You're not going to have much wriggle room if you've missed your contractual deadlines. So sorry about that. I think it is really onerous, and it's come a long way, and not in a good way, for contractors. In the last 10 years ago, I don't think we would not have had this at all. But it's where we are now. I think it will subside and we'll kind of get a mellowing, and the courts will go off this idea of supporting time limits, when to the detriment of parties who lose money because they haven't complied with a notice within a time limit. But this is where we are at the moment, so we just need to deal with it. Very quickly, changing the project manager. We've seen the ICI case before, so this was a troublesome matter for both parties. It's not gone well. The key thing here was that ICI was the client, the employer. The project manager was an independent firm, and ICI wanted to get rid of the PM and did, and wanted to appoint a new PM, as it's got to. But what it wanted to do was to appoint someone from inside of ICI, so an employee. Meritrill weren't very happy with that, and the court said, you absolutely can't do that unless you have a provision in your contract, so it would be a Z clause, an amendment, to say, if we want to change the PM, we reserve the right to appoint someone from within our own organisation. Now that applies where the original PM is a consultant. If the original PM had been within ICI, then they wouldn't have had a problem. So contractors, just make a note of that. This kind of thing, may happen if things are going sour between the parties. So if your client tries to do that, you've got a case to rely on to say you can't do that. And equally, employers, be careful when you're doing this. because, you know, you don't want to get into adjudications and court proceedings over things like this. Now, what I would say here was, you know, you'll see from, you know, a little bit of, you know, the story and the bullet points, you know, this wasn't going well. And I think the court took the view that ICI wanted their own person because they didn't want an independent PM. They wanted someone who was partisan. So that didn't impress the court. And of course, one of the cases that I haven't talked about here is Costain and Bechtel, where it's not binding, but there was dicta. So, you know, a general view from the court that, you know, PM is there to act impartially in terms of making interim assessments, not there to be partisan. I'm going to very quickly cover this. So this is SSE and Hochtief, NEC2. This is a bit of an unfortunate case where they constructed a tunnel and it collapsed. They had all risks insurance policy and joint names, but the client instead chose to sue the contractor direct. The contractor tried to say, no, we've got insurance in joint names, you can just claim under the insurance. Client didn't want to for whatever reason, and relied upon this clause 83.1, which says each party bears the risks of its own negligence. And the court said, yeah, that makes it clear. If there is negligence, then just because there's a joint names policy doesn't mean that the negligent party can't be sued. So, you know, we need to amend that if it's not going to apply. So that's potentially very onerous for contractors. Note it's a Scottish case, but to be honest, I can't see the courts here having a different position on that. So that's everything for today. I hope it's been useful. As I said, that is pretty much all of the case law. So, you know, you can sleep sound at night in the knowledge that you've covered it all. I'm happy to answer any questions. I can't see any questions coming up. I think my email details might be on the slides. But what I always say is, you know, if you think of any questions later, I'm always happy to, you know, answer email questions or just pick up the phone, because I think my phone number is on there. It's all definitely on our website. Do ring me on my mobile though, because we're not in the office at the moment. I can't see any questions. All right, Gemma's waving to me, so that means bye. I don't know. Are you going to do a finishing bit, Gemma? I still can't hear her. Right, I'll hand over to you. Thank you.
Unfortunately, Sarah is in a black hole somewhere and for some reason cannot hear me, which is fine. It's probably for the best for Sarah. If anyone does have any questions, you can bob them on just now. But as we've said, Sarah's details are on the information. If you'd like a copy of the slides, I've already had a few people drop me an email. You should have my contact details on the registration email that you've received, so I can get a copy of the slides sent out to you. That's not a problem at all. Just reply and I'll get them sent out. Equally, if there's anyone within your organisation who's missed today's session and would like to come along, we will have a recording of this available probably next week, and I'll send this across to everyone as well. So if no one has any questions, I'd just like to say thank you very much to everyone for coming along. I'll just read out Mark, our Executive Director for Yorkshire and Humber, who would like to thank Sarah for her ongoing support for our association and members. Again, it's always really, really appreciated. And I know our members have appreciated managing to keep these seminars going through this difficult time. So from us, thank you very much, everyone. We look forward to seeing you at one of our next events and in the new year. Take care, whatever tier you're in. Everyone look after themselves, and we'll hopefully see you soon. Thank you very much, Sarah, who can't hear me. Thank you to everyone else, and we will see you